How's it going, everybody? This is Attorney Anthony Miranda with the Firearms Policy Coalition. Today I want to bring to your attention an interesting case which recently had oral arguments before the Supreme Court called Caniglia v. Strom. This case involves a question of whether the community caretaking exception to the Fourth Amendment's warrant requirement extends to the home. In 1973, the Supreme Court decided a case called Katie v. Dombrowski, in which it held that the police officers had not violated the Fourth Amendment by searching without a warrant the trunk of a car that had been towed after an accident, because it was part of the officer's community caretaking functions. A warrantless search of an automobile could thus be constitutional, but Katie was largely based on the differences between automobiles and homes. In this case, the First Circuit Court of Appeals held that the community caretaking exception to the warrant requirement could also apply to home searches. So how did we get here? Well, during an argument with his wife of 27 years, Mr. Caniglia retrieved an unloaded gun and asked, "Why don't you just shoot me and get me out of my misery?" Eventually, his wife decided to stay at a hotel. The next morning, Mrs. Caniglia called her husband, but he missed the call. Concerned, she called the police and told them about the argument they had the night before. Mr. Caniglia was taken for a psychiatric evaluation and was discharged on the spot. But in the meantime, the officers entered the Caniglia home without a warrant and seized Mr. Caniglia's firearms, claiming that it was part of their community caretaking responsibilities. As you can see, this case is not directly related to Second Amendment issues, but instead addresses Fourth Amendment rights and how the community caretaking exception could be used in a way to ultimately seize firearms. Oral arguments in this case were heard by the Supreme Court on March 24th of 2021. Plaintiff's counsel during oral arguments was questioned heavily on hypotheticals like when a law enforcement officer could enter a home without a warrant or consent. This included hypotheticals like, for example, an elderly neighbor was supposed to come to dinner but doesn't. What if she is never late and no one has heard from her or can't get a hold of her for 24 hours or more? Then can the police come into a home and check on her? As Justice Kavanaugh put it during the oral arguments, the issue of warrantless and consentless entry questions fell into two main buckets: when dealing with the elderly or when dealing with potential suicides. In contrast, defendant's counsel was questioned heavily on how they got from community caretaking checks on vehicles that were impounded in Katy to entering homes without warrants and consent, as was the case here. Many justices also showed great concern that if the defendant's theory was adopted, then law enforcement could enter the home under countless scenarios, since many situations can be brought under the umbrella of public health and safety. FPC and FPF, along with Independence Institute, filed a brief supporting Mr. Caniglia in this action. The brief emphasized the historical significance of the sanctity of the home, arguing that the police should not be able to conduct warrantless community caretaking searches of a home. Starting with Cicero's philosophy in ancient Rome, then moving to the 5th century England through colonial America, and ultimately to the debates over the ratification of the Constitution, FPC's brief illustrates that the home has been considered sacred for over 2 millennia. Specifically, in colonial America, abusive home searches were met with great hostility and violence, so much so that by the time of the American Revolution, even lawful home searches could rarely be conducted. The brief points out that under the Fifth Circuit's standard of community caretaking searches, many of the searches the founders so vehemently opposed would now be permitted. The brief was authored by FPC's Director of Constitutional Studies, Joseph Greenlee, along with David Koppel of the Independence Institute, and Lauren McLean and George Moscree of the University of Wyoming Law School. This brief, along with additional resources on this case, can be found at fpclegal.org. While you're at it, please head on over to joinfpc.org. Your donations go directly to helping our team fight against these types of 2A infringements and more infringements as well. Once again, this is Attorney Anthony Miranda with the Firearms Policy Coalition. I'll see you guys next time.